Good evening, everyone. Hi, I'm Norman Provan. I'm the Associate Director of the Royal College of Nursing in Scotland, and I'm chairing this event this evening. The event this evening is about the terms and conditions of employment in the independent health and social care setting, and it's particularly important for internationally educated nurses. So this evening I've got two fantastic speakers for you in the webinar. First, we have Claire Sutton, Transformational Lead for Independent Health and Social Care, who's going to do about 20 minutes on contracts and key terms and conditions, unwritten terms, changes to terms and conditions, and issues about resigning. And then Sophia Barrett, who's joining us, who also will do about 20 minutes on legal repayment clauses, being dismissed, disputes with the employer, and recruitment agency issues, including the immigration skills charge. Following the two presentations, I'll just do a couple of minutes about benefits. I've been a member of the Royal College, and then we're going to follow that with 20 minutes of Q&A. So what I would ask is, if you have any questions that you would like to ask, then just post them in the Q&A button, which is up on the right-hand side at the top of your screen. So just click on that and you can put any question you have, and we'll try and get through as many questions as we can before the end of the event tonight. What might be quite helpful when you're asking the question, if you particularly want to ask a question that's for Claire or Sophia, then if you could just make that clear in your question, that would be fantastic. If not, I'll just throw it out there and either Claire or Sophia can come in, whichever one feels best set to answer the question. So welcome everybody, and I will do nothing further than to hope you all enjoy the evening and find it useful, and hand over to Claire Sutton for her presentation. Claire.
Thank you very much, Norman. Hello everybody, my name is Claire Sutton. I'm Transformational Lead for the Independent Health and Social Care sector here at the Royal College of Nursing. So a huge proportion of our members, much like yourselves who've joined this webinar tonight, work outside of the NHS. So you work across independent health and social care, and that represents many, many thousands of different employment settings. Next slide, please, Will. So what is a contract of employment? I think that this is something that we need to, we can't assume that you and everybody knows what a contract of employment is. So we at the RCN believe strongly that all of the nursing workforce, so that's registered nurses as well as nursing support workers, should be recognised and valued through fair pay terms and conditions. And a contract of employment is a legally binding document. So you should always read any contract that you are presented with fully and make sure you understand that before you sign it. It's really important. Once you sign that, it's legally binding. So anybody who is classed as an employee or worker has the right to a written statement of employment particulars. And sometimes a written statement is referred to as an employment contract, but by law, the employment contract is much broader than just that written statement. It should include, amongst lots of other things, the main terms and conditions of your employment. So, for example, how much you should expect to be paid and what you should expect your working hours to be. Next slide, please. So, the other things that it can include things around what you should do with keeping sensitive information safe, the code of conduct of the organisation that you work for, and it could include some of their particular policies that they have in their HR department. You may find that it just refers to other policies, but again, when you make sure you sign that and you understand it before you sign it, if it does refer to other policies, ask to see them. Next slide, please, Will. I'm so sorry, I'm just going to cough. Sorry about that. Okay, so your contract of employment can be changed. So it's legally binding for both you as an individual, but also your employer. So you can't, it's generally not legal for somebody to just change the terms and conditions of a contract without the agreement of the other party. So your employer can't just say, we're completely changing everything. You would have to agree to that and you'd have to sign a revised contract. There are some circumstances then where that contract can be changed. So that's if both you and your employer agree to that change. So you're presented with a new contract, you read it, you understand it, and you sign it and get a new one. If your original contract covers something in there that says we may be able to make changes, so you might find that there will be some flexibility in there. You can only make reasonable changes with that. So if it'll say things like there may be elements of flexibility, we wouldn't expect that would mean that you could suddenly be asked to work 100 hours a week or completely change that location of where you work. It would be reasonable changes. Without that, if they were classed as unreasonable, that first bit about both you and your employer agreeing on the change would come into play. So there needs to be a collective agreement that's binding on you, and the terms of which are changing through negotiation. So that's if you've got trade union representation where there is collective bargaining, so that is negotiated for changes to your pay terms and conditions, or if your employer terminates your existing contract and substitutes it to a new one, which might include the variation. Always make sure you check what that flexibility clause is, because it can enable some changes to be made within that. And this is why it's just so important to make sure that you read and understand your contracts of employment before you sign them. Next slide, please. It's really common for contracts of employment to have a probationary period added into them. And that starts from the first day of your work, and it can last for a number of weeks or months, and that will vary. So some people will have a month, some people might have 3 months, 6 months, 12 months, and that's really common and normal, and it should be detailed to you in that contract of employment at the beginning. You can find that some employers will offer less favourable terms and conditions and maybe a lower salary during a probationary period, and they can do this as long as it's detailed in that contract, but they cannot take away your basic statutory rights. So you have legal rights as an employee, and even in a probationary period, what your employer offers cannot be less than those legal rights. I'm so sorry. So you are classed as being continually employed from the start of your first day of work, not when your probationary period ends. That can be really important if your employer uses things like accrual of annual leave. So the your period of employment starts from day one. So you need to make sure that it's not the end of your probationary period. Next slide, please. The thing with probationary periods is they can be extended. So there needs to be a reasonable reason and a reasonable length if your probationary period is being extended. So say, for example, you've been unable to demonstrate your capabilities of certain criteria because you've been absent due to sickness. It would be perfectly normal and perfectly acceptable for your employer to say, OK, we're going to extend your probation by a month because you've been off for a month and we need to ensure that you meet the requirements of the role. What they must do is provide a reason why that's being extended. They can't just do it without explaining to you the reasons. Your notice period should also be detailed in your contract as well. So we've got all of this in our advice guide, and the links to the advice guide are on the last one of my slides, so you will be able to see that. But also, if you've got any performance issues during your probationary period, then that can be extended. But objectives should be clear and understandable, and they should be SMART, so specific, measurable, achievable, relevant, and time bound. And that's to enable you to be able to work towards passing those issues and completing your probationary period. Next slide, please. So the really, really important things, and I'm going to keep labouring this point, is never ever sign a contract that you don't fully understand. If there are if there is anything that you're unsure about in that contract, seek advice. So you can contact RCN Direct and they can give you support if you remember. And there's loads of advice guides on our website as well, but you must not sign something if you don't understand it. If you've got a contract that's got blank spaces, don't sign it, because those spaces shouldn't be blank. All the information should be in there. Don't place reliance on verbal promises. It's really common for people to give verbal assurances, but it's very hard to prove that. So make sure that you do have things in writing. Watch out for any repayment clauses that might be added into your contract. Some of those can be enforced if you want to leave your employment. Ask for copies of documents and policies that are referred to in that contract. So I mentioned earlier that a full contract might include references to other policies. Make sure you've read and understood those before you're signing it as well. So if you're not provided with copies of anything that's referred to, ask for a copy of it. If you're unsure about things and you need to seek clarification from your employer, ask for written clarification. Again, just to kind of go back to that point about not placing reliance on the verbal promises. If you're unsure about something, get it clarified in writing, and make sure that if you've got any objections or anything that you want changing in your contract before you sign it, that you put that in writing as well, so that you've got that paper trail before you commit yourself. Next slide, please. So the contract of employment starts when you start work. That is even the case if your employer hasn't given you a written statement or not put any other parts of the employment contract in writing. It still starts the day you start work. So this is why it's really important to ask for your contract ahead of starting work. It might start earlier than when you actually start work, and that is laid out there. So it's if you've got it all in a clear and definite way, your job offer's unconditional, or you've met all of those requirements, and if all the references are back and they're satisfactory, and if you accepted the job offer verbally or in writing. Next slide, please. There are some terms of employment that are just too obvious to be automatically written down in a contract of employment. So these are really obvious legal things, like don't steal from your employer. As a registered nurse, don't harm your patients. And these won't be specifically written in a contract of employment, because it is just implied that you and everybody who is an employee will know that you're not to steal from your employer. And because they're statutory, it means that they come from law. There are some, though, that are implied through customs and practice. So that's if they're necessary for the efficiency, the efficacy of the business running. And it's that they're around your conduct in work as well. So these are things that you should, these would not come as a surprise to most people, basically, and that's why they are implied. That's why they don't need to be written down, because it is assumed that you will know these things. Next slide. A little bit more on this. So they are too obvious to be written down. They're implied because they are so obvious. In an employment tribunal, if you ever find yourself in a situation where you were in one, the judge would consider them to be too obvious to be written down. And even if they're unwritten, they're often really crucial for making sure that you work effectively and you have that good relationship between your employer and your employee. To prevent any kind of misunderstandings, your employer should make it clear what those standards of behaviour are that are expected. So your employer should make it really clear that you've got to be polite to the people that you're supporting as a healthcare professional, or if you work in customer service. You would be. Next slide. They should also, You should also be aware of what might happen if these terms that are too obvious to be written down in your contract are not met. So, for example, if you steal from your employer, they're going to contact the police because it's a breach of law. You have committed a crime potentially. And they should also make it clear the standards of behaviour that you as employees can expect from them. So, for example, what support they might put in place to meet their duty of care. So if they've got an employee assistance programme, for example, or if they have access to mental health first aiders for you, they should be put in writing in an employee handbook. Most employers will have an employee handbook and you can have access to that. Next slide. So if you find yourself in a situation where your employer breaches your contract of employment, you can respond in a couple of different ways. So you can agree to that breach by continuing to work under the revised terms. You can raise a grievance or make a claim to an employment tribunal, and you would have need to make it really clear to your employer that you don't accept the new terms and conditions. So if they make a change to your contract of employment, you've not signed it, you need to tell them that you disagree with it. Or thirdly, you can refuse to work under the new terms. So your employer might then decide to dismiss you and rehire you on a new contract if you wanted to. If that happens, you might be able to bring a claim against your employer for unfair dismissal. But it's really important for you to be aware that employment tribunals do frequently find dismissals fair if the employer can point good reasons why they have made those changes in that contract of employment. If you are in this situation or you find yourself in this situation, please make sure that you contact us at RCN Direct before you take any action, because we've got a brilliant legal advice team who can give you that advice and make sure that you make the right decision for the situation that you are in. Next slide. Changes of shifts are something that can be quite common. And if your employer wants to change your shift pattern, we've got a specific advice guide on that that also gives you details of your legal rights. You may find that your contract of employment or the local policies of your employer allow changes or flexibility to your shift pattern, providing they follow the correct process. So we as healthcare professionals work in a 24/7 society. Certainly in the independent sector and a lot of social care settings, you may find that your shifts might move from days to nights. Check your contract of employment, because it's very likely that it would suggest that you can work different shifts as the needs of the organisation require. If you've got a legal right to continue working on your existing shift pattern, so if you've got a shift pattern that is detailed in your contract and you don't want to change it to what they're asking you to change it to, discuss it with your employer. And if you can't resolve it directly with your employer, contact us and we will support you with that. If you want to change your hours or pattern of work, because as we said, contracts work two ways, then we've got an advice guide on flexible working, because you may find that you want to make a request to your employer to say, actually, I'd really like to change shifts to work slightly different shift patterns. Okay, next slide. Don't worry, everybody, we are coming to the end of my bit here. If you want to leave your job, you will have to give notice of your intention, so notice of your resignation. How long you have to give will depend on your contract of employment. So sometimes it will say you have to give a week's notice, a month's notice, 3 months' notice, and it should be detailed in there. There are situations where something called layoffs can happen, and that's where an organisation may not have a sufficient amount of work to sustain the workforce that they've got, so they may lay staff off. They may also bring in something called short-time working, and that's again where there isn't a sufficient amount of work available an employer lowers the amount of hours that an employee is expected to work. Unless your contract states otherwise, your employer is legally bound to pay you for your contracted hours and should not be telling you that you have to pay time back at a later date. So if you find yourself in these situations, unless it's already detailed in your contract, there is legal obligation for you to be paid for your contracted hours. If your employer could make a claim for damages against you if they suffer measurable financial loss due to you breaching contract. So they can do this by either claiming against you or counterclaiming in an employment tribunal. In practice, it's pretty rare, but it can happen. Next slide. These are the people you should contact. If you find yourself in a situation where you need specific advice about your individual situation, contact our advice team at the Royal College of Nursing and we'll support you with that. The next slide, please, Will, is literally just some links to all of the information that I've talked about here. So we can pop those links on the webpage, I think, possibly in the chat for you as well, so that you can access those. It will literally give you more information about what I have whistle-stop toured through. So that is my section over, and I'm going to hand over to Sophia, and thank you very much.
Thanks, Claire. That was really useful information that you've given this evening. So just before I pass over to Sophia, I'm conscious of the fact that a few people possibly joined just a few minutes after we started the event tonight. So just to reiterate a couple of things. One, if you have any questions for the Q&A, if you can just post them on the tab that says Q&A, it's up in the top right-hand side of your screen. It means that when we get to the end of the presentations, if you have anything that we haven't covered or you want more information on, ask us a question in the chat and we will try and answer them as best we can. And for those who missed at the very beginning as well, the slides from this evening and the event is being recorded will be on our website in a couple of weeks' time. We put captions and stuff on it so people can see if they can't hear it too well. So that'll be on in a couple of weeks' time. So if you have friends or colleagues who you think would have value in being here tonight but couldn't join us, there will be an opportunity for them to go on the website at a later date, look back and see everything that's been said tonight in terms of the presentations. So thanks very much for that, Claire. That was really useful. And if when you're asking any questions in the Q&A, if you particularly want it to be for Claire or Sophia, just write that. If not, I'll pick who I think might be best to answer your question. So we would value any questions that you have. So I'm just going to hand over now to Sophia Barrett. Sophia's from our membership services and she's going to speak about legal issues, including repayment clauses, issues about being dismissed, disputes with your employer or recruitment agency, and issues in relation to the immigration skills charge. So Sophia, over to you.
Great, thank you, Norman, and thank you, Claire, for your really useful presentation. My name is Sophia Barrett Malangini. I'm an immigration solicitor, not an employment solicitor, but I will take you through this evening around the issue of repayment clauses and unlawful deductions from wages. Next slide, please. So the issue around repayment clauses and how they have been applied specifically to migrant nurses and migrant workers generally in the health sector has attracted considerable attention from the media in the last couple of years. And we've just got a selection of some of the press reports in relation to quite poor and behaviour from employers when it comes to the issue of deductions from wages. Next slide, please. So the issue around unlawful deductions, employers cannot simply deduct money from a worker's salary. Deductions are strictly governed by law. And it's important that a worker acts quickly if they suspect an unlawful deduction has been made. an issue claim within 3 months of the last deduction. So it's important to examine the contract very carefully in respect of the date that the payment was actually due. Next slide. So are these deduction clauses lawful? Well, they are. If the employee has signed a contract of employment, it's a binding agreement, as Claire had mentioned in her presentation. Once you've signed that contract, you are legally bound by that the terms contained within that contract. So penalty clauses, they're designed to deter parties from breaching the contract. They sort of act as a punishment to parties who haven't adhered to the terms of the contract. Penalty clauses you cannot make deductions from penalty clauses. The only clauses that attract or are permitted to be subject to any sort of deductions can be made are liquidated damages contracts or clauses. Liquidated clauses are designed to compensate the party that's not at fault. Next slide. So in determining whether there has been an unlawful deduction from wages, it's important to ask 3 questions. So is the sum legally due? And if so, what is the sum? Has there been a deduction from the sum due? A deduction occurs if there has been a shortfall in the amount of wages when compared to the amount properly payable. And lastly, was such a deduction authorised under the law? So it's important to go through these steps when actually looking at an unlawful deduction from wages. Next slide, please. So here's 3 examples, and they're quite common examples of repayment clauses. So obviously there's a common scenario of people who decide they want to leave an employer before the fixed term of the contract. So there's examples here. For example, if training was completed and a certificate was awarded, if the employee leaves less than a year after any training course, then the company will request payment of the cost calculated on a sliding scale. Next slide. So it's important to emphasise here exactly what is a penalty, what is a penalty clause, or a genuine liquidated damages clause. In these situations, always seek advice if you're not clear as to what the repayment clause actually means. So if you have been offered a employment and you've been issued with an employment contract, and you can see clearly there's a section on repayment clauses and you're not quite clear what these actually mean for you before you sign that contract, you absolutely must obtain advice. I mean, even if the employer may want to be compensated for any loss that they have experienced due to an act by the employee, namely leaving employment, the amount that they claim, it has to be proportionate. They can't just pluck a figure from the air. That's completely unreasonable. Next slide, please. So, for example, it's not unusual, certainly when I've spoken to members, to say that they didn't receive training, but they're being told that they have to repay the costs of training. So it's important to provide sort of evidence of if you didn't receive that training, so you haven't got a certificate, for example, then that's something that you can challenge the employer in relation to having to repay any sums owed for training. But I've also had situations where members have said that they themselves have paid for that training, even though the employer has said that they would actually incur that cost. Important to keep receipts, keep evidence of any costs that you have incurred that the employer is saying that they incurred themselves. It's important to have evidence. The immigration skills charge is a fee that employers have to pay when they issue a certificate of sponsorship to a skilled worker. It's very clear, the Home Office makes it very, very clear that this is a fee that is incurred by employers only. They mustn't pass this charge on to the worker. If there's a situation where there has been a deduction and the employer stated, well, it's because you have to pay back the immigration skills charge, that is something that would be unlawful, because it's a fee that an employee, a worker, should not be paying back. Next slide, please. The Department of Health and Social Care have provided provided a very useful code of practice for employers who recruit healthcare staff. Although the code is voluntary, there is an expectation that employers will follow that code. The code also has an appendix, also has a section that contains a list of ethical recruiters. Now, if an employer who is on that list of ethical recruiters, if they're found to have breached the code, they can actually be removed from that list. The code makes very clear that any repayment clause must abide by 4 principles of transparency, proportionality, proportionate costs, timing, and flexibility. And the code also states that costs are recoverable, are expenses actually met by the employer, such as visa fees, relocation expenses, and regulatory exam fees. It's always important to obtain evidence that the employer has actually incurred the costs that they say that they have done. Next slide, please. So the code in relation to the costs that an employer is liable to pay, there's a list here. So you've got the agency fee, immigration skills charge, sponsor license fee, cost of the interview process, interest on any amount on any claim. So these are things that the code of practice says that it's not reasonable to expect a worker to pay any of these things that's listed. The code also states that the employer should also give the worker the option to repay the costs through a monthly plan. So this is something that if you're found to have been liable under the repayment clauses, the code of practice does say that the employer should allow a worker to actually organise a repayment plan, as opposed to having to pay the full amount. Next slide, please. So a repayment schedule must be provided, and rechargeable costs must taper downwards with time. So the code gives sort of examples as to how a repayment schedule would actually operate in practice. Next slide, please. So generally speaking, RCN will only assist if you were in membership at the time of the incident. However, there is a special provision for internationally educated staff, and we can see here instances where the RCN will assist if you haven't been in membership, or you weren't in membership at the time of the incident. So it only applies where the member is an internationally recruited nurse and it's their first job in the UK. It's within 12 months of arrival, and the member is in membership at the time of the of contact. So RCN at this stage, RCN Direct will refer the worker, that will refer the member to their regional office for RCN regional office for support. Next slide, please. So there have been instances of employers passing on the cost of the immigration skills charge, and as I said earlier, it's very clear. It's made very clear by the Home Office that this shouldn't happen. Employers should not be passing this fee to employees. The purpose of the immigration skills charge was really a sort of an extra fee for employers to actually encourage employers to recruit from the local workforce rather than from abroad. So it's something that the Home Office applies specifically to employers. It's not something that the immigration skills charge is not a fee that the worker has to pay. And in fact, if the Home Office find out that an employer has been passing on the immigration skills charge onto their workers, sponsored workers, they can actually lose their license to recruit from abroad. So they can actually lose their ability to sponsor workers. Next slide, please. Okay, so that's the end of my bit on repayment clauses. So now I'm going into more familiar territory now and dealing with the consequences or the impact of leaving employment as a sponsored or skilled worker. So next slide, looking at topics. So the topics I'm going to cover is what does the employer have to do when a sponsored worker leaves employment, and what does a sponsored worker have to do when they leave employment. I won't really go over the immigration skills charge because I've covered that quite a bit in previous presentation, and I'm going to look at curtailing leave to remain or permission to remain in the UK. So next slide, please. So first of all, employer's duties. So a sponsor has to inform the Home Office if a worker leaves. That's as a result of resignation, or they've been dismissed, or there's been a redundancy. So it's not a sort of punishment that the employer has contacted the Home Office because you've left, a worker's left. They simply have to let the Home Office know that sponsorship has ended. Ending sponsorship does not mean the visa has somehow been revoked, or the visa has ended. It's literally just the sponsorship with that worker that has ended. The sponsor has to notify the Home Office within 10 days of that worker leaving employment. Next slide, please. So the sponsored workers' duties. So once a worker has left employment, they need to obtain a certificate of sponsorship with another employer. Once they have obtained that certificate of sponsorship, they have to update the Home Office with details of their new employer. So it's an online application form that has to be completed, and once that has been approved, the worker can start working with that new employer. You cannot start working for that new employer until you have received a successful decision from the Home Office. Next slide, please. As I said, I won't go over that. So next slide, please. So this is quite important. So curtailment of leave to remain. So once, as I've mentioned earlier, once you have left employment or your sponsorship has ended, the employer has to notify the Home Office of that event. So the Home Office have effectively been made aware that you're no longer being sponsored. So they're essentially expecting you to do something. So are you looking to go into a different immigration category completely, or do you still want to remain as a sponsored worker, but you're now going to work for a new employer? So the Home Office are waiting for you to do something with regards to your to update your permission to remain in the UK. If you wait or leave it for too long to submit an application, the Home Office can actually curtail or shorten your permission to remain in the UK to 60 days. So if you've got 2 years left on your visa, you've taken, after 3 months or 4 months of leaving your last employment, you haven't submitted an application to the Home Office, then the Home Office will give you an ultimatum. They will say to you, you have to do something. You either have to submit a new skilled worker visa application or some other immigration application or leave the UK. Now, the question that I'm always asked is, well, how soon after I've left my employer will I have to find a new job? When would the Home Office contact me about this? There is no set time. As a rule of thumb, I generally advise members to don't delay. If you've, for example, if you've been dismissed, I would generally advise people to attempt to submit a new application within 8 to 12 weeks of that dismissal. Once you get past 3 months, and the Home Office aren't going to contact you to curtail your permission to remain within a few weeks of leaving an employer, but certainly after 3 months, you really are on borrowed time, and you really need to get an application into the Home Office fairly quickly. The 60 days deadline will be specified on the letter or email. The 60 days will start from the date of that letter. So it doesn't start from the date that you left employment. It will start from the date on the letter that the Home Office will send if you have taken too long to submit an application. Next slide, please. So that's the end of my presentation. I'm going to hand you over now to Norman, who will inform you about the benefits and reasons to apply for a membership of RCM.
Thanks, Sophia. That was a really interesting presentation. Lots of information in that. We haven't had many questions published yet, so if you do have any questions, please post them in there and we'll get to them in just a few minutes. So just for a couple of minutes, just to go through some of the reasons why you should join the Royal College of Nursing. I'm assuming that many of you have already. But if you haven't, this is useful for you to know, and certainly it would be useful for you to pass to any colleagues who you think might benefit from joining the Royal College of Nursing. In terms of professional development, as a professional body, we support your lifelong development and learning, and the RCN has got an amazing array of resources for people. We have the largest nursing library. We have forums and networks that you can join, which can be very specific to the particular area that you work in. So we have forums for all different clinical disciplines, people working in cancer or community or mental health. So you can join a network of people who are working in similar circumstances to you and get professional support that way, as well as the learning resources that we have and access to the library. We also, of course, offer workplace support, and we are, as the only nursing-specific trade union in the UK, we can provide you with the specialist workplace knowledge, support and guidance should you require it in your workplace. So that includes if you need representation from an employment relations officer, or just advice in relation to the circumstances in which you're working in anything that you think that you need particular union advice in relation to. In terms of legal advice, we have a comprehensive support and information from our in-house legal team in the UK and in Scotland from an external legal provider. So we have lots and lots of resources that if you individually require to be helped with a legal case, then if you're a member when the issue occurs, then that of course is entirely free to you. In terms of member support, we provide a lot of emotional and practical support. We have over 400,000 nurses who are members of the RCN, and we provide immigration advice, welfare guidance to support you in your financial well-being. We can provide career coaching on CV writing, preparing for interviews, career planning, telephone counselling for people if they need additional support, and peer support for members with disabilities. There's a guide to common English expressions, which is quite helpful for people, particularly who are internationally educated or recruited. And we provide a bespoke careers service where an extensive nursing careers resource can be helpful to give people guidance in planning their career, working in the UK and whichever sector you've chosen to work for. So there's lots of benefits to being members. Taking account registered and healthcare support workers, we have more than 500,000 members, which makes us uniquely positioned to offer services to nurses and healthcare support workers. So if you're not a member, I would urge you to join. Certainly the presentations that you've had from both Claire and Sophia today show how important it is that you guys get the representation that you require. And obviously we would encourage you to be a member so that you can access all of those benefits and certainly pass them on to any colleagues that you have working with you who are perhaps not members, but you think would benefit from joining the Royal College of Nursing and accessing those services. I'm going to move us on to the Q&A. So we have some published questions. I'll take a couple of them that are just comments. So Abigail had asked for a list of the contacts to be emailed to you. So they have now been added to the bottom of the chat, Abigail, so you should be able to access them there. And I would remind you all that this is a recorded event, so it will appear on the website in a couple of weeks' time. So if you want to watch it back, just as a reminder of what was said in the event today, you'll be able to do that and access the links via that way as well. So just moving into some of the questions, Gabriella asked, could it be stated in the contract how long the induction must last? And could the induction be prolonged if you're not confident enough? So Claire, I wonder if you could answer that for Gabriella.
Yeah, of course. Thanks for the question, Gabriella. So yes, it may well state in your contract of employment the anticipated period of an induction process. And yes, it could be extended if you don't feel confident enough. Induction processes, again, much like contracts of employment, work two ways. So you've got, if you don't feel that you are being supported through your induction, you can ask your employer for more support. Sometimes an induction process is tied to a probationary period. So it may be that if you're not feeling confident that your induction process might be extended and your probation period might be extended in line with that, but you shouldn't see this as being a negative thing. It works two ways, and your employer is there to provide you with a supportive induction process and to help you get through that. So I hope that answers your question. If not, please feel free to pop something more in the Q&A.
Thank you very much for that. Thank you very much for that, Claire. That's helpful. A couple of things have been put in the comment. I don't have a name for this one, but somebody has said, is there any way that you can reach out to new overseas nurses, as there are many out there in the community that need help? We do our very best in terms of that. We have lots of information on the website, but certainly you guys who have been internationally recruited probably see people in your own workplaces in those circumstances, so point them in our direction. The website's free to access for anyone, and the ability to join is there, and there's lots of resources that people can take off of the website. We do try our very best. Another comment that was put was in relation to some of the distribution of RCN material not been equally done. From Abigail, who's been a member for 3 years and has seen colleagues getting pens and T-shirts and other promotional material. What I would say, Abigail, is that we try our very best to get that out as equally as we possibly can. However, the independent sector often doesn't have the same ability for our reps to function in there, or indeed our staff to visit. So it can be sometimes difficult for us to get access to internationally recruited nurses in the same way that we do in the NHS. But what I would suggest you do is ring RCND or get in touch with your regional office and see if you could get them to arrange a drop at the place that you work, because often they will drop off promotional materials, which will have leaflets and information that would be appropriate to you, and some of the giveaway stuff that we have for promotional, like pens and pads and all of that kind of stuff. So I have another couple of questions I'm going to pass over. The first one is anonymous, so I don't have a name, but the question is, why will employers ask staff to repay costs and training back to them when they want to leave work after the staff have used the skills to provide services to the employer? I think it's not fair. So could I ask Sophia, could you pick that one up for me, please?
I mean, I'm sorry, I'm just trying to find this. So could you just repeat the question for me again, Norman? I was just trying to find it
Sure,
in the
it's
Q&A.
anonymous, so I don't have a name.
Yeah, sure.
And it's why will employers ask staff to repay cost of training back to them when they want to leave the work after the staff they have used the skills to provide services to the employer? I think it's not fair.
Yeah, no, I mean, I completely understand that. I mean, ultimately, everything will be decided by what's in the contract. Ultimately, unfortunately, if the contract does state that training has to be repaid if you leave within a certain time, unfortunately, you will be bound by that. As I said in the presentation, I mean, I've had instances where training hasn't happened, and the employer is somehow asking for that money to be paid, and in that instance, it's up to the employer to provide evidence that they had paid for any training, and also again, the worker has themselves paid for their training themselves. So in that instance, you keep all evidence via receipts that of what you've paid. But no, I mean, I'm very sympathetic to that view. It doesn't seem fair at all, but ultimately it will be governed by what's in the contract and what was signed.
Thanks for that, Sophia. I notice Abigail's put in the chat that she's ready to become a rep in the private sector. That's fantastic, Abigail. Could I advise you to contact your regional office? You'll be able to get that off the website. It gives a list of the regional offices, so you'll know where you work. And if you contact the regional office, they can speak to you about the process of becoming a rep. I thought I seen another question there, Carol. Yeah. Can I just take Chair's license in relation to a question? Because we don't have any more written questions at the moment. So, Sophia, I wonder if you could answer this. I've had a couple of cases recently in Scotland for nurses working in the independent sector who, after about a year, were offered jobs in the NHS. And in their contract, there was repayment clauses for them to pay back, but the employer has tried to add on things that wasn't in the contract, in particular training. And what they've done is said that they're going to refuse to give them a reference for their NHS job until they pay all of the money back. So although they know they're not obliged to pay it back, they feel they have to or they won't get a reference. Is that common, and what advice would you give members in those circumstances?
Yeah, I mean that is quite. We found that certainly the queries that come through to us in the immigration team, where a reference is sort of held over. I mean, the situation with references is that an employer doesn't have to. They're not legally bound to provide a reference, but it's always worth just checking what exactly is being asked to repay, and can the employer provide evidence that they have incurred those expenses. So are those expenses what they're asking for? Is it proportionate? Is it lawful within the contract? So it's always worth, as a starting point, challenging those actual sort of deductions that the employer is trying to recoup. But yes, I mean, it's very common, we're seeing, with regards to using a reference, or not providing a reference as a means to get the worker to repay. Yeah, I mean, the issue is always challenge. Are those deductions challengeable?
Thanks, Sophia. That's useful. I do have two other questions that have popped in. So the first one is, the period of only 60 days to gain new sponsorship is a really short time. If the individual also has accommodation with employment, it's a great deal to organise with very little time. Where would you signpost people for assistance if they're struggling to find new employment and accommodation other than at the RCN? I don't know whether Claire or Sophia, I don't know which fields would be best. I think Claire, perhaps.
Yeah, so I would first and foremost strongly encourage people to contact RCN Direct. We've got employment advice specifically, we've got immigration experts, we have got people who will support with that. The 60 days is incredibly short. It's really difficult because it is so short, and you have to gain new sponsorship from an approved organisation that has got sponsorship. The Home Office can provide you with advice as to which employer organisations have sponsorship. That is a good starting point, but I would first and foremost really encourage anybody to reach out directly to RCN Direct and get individualized advice for their specific situation. It's very complicated, it's very difficult, and 60 days is very short.
Yeah, I mean, can I also just add one thing as well, because I think when people get into that situation where they haven't submitted a timely application to the Home Office because they've just found it difficult to locate new employment, sort of desperation sets in, and it's at that point you could be quite vulnerable to abuse at this point, where you have recruitment agencies that will actually charge a fee, and will promise that they will get you a job, they'll get you an interview. First and foremost, a reputable recruitment agency wouldn't charge a potential worker, so that should always be a red flag. So as I said, if you go to NHS Employers, actually has the list of ethical recruiters. So it's always worth having a look at that. And as Claire's mentioned, the Home Office does also produce a list of licensed employers. So don't, in sort of desperation, pay an agent, a recruitment agency, to locate a job for you. That should be a red flag.
That's really useful information. Thank you both. Gabriella has also put in the chat that she has colleagues that haven't worked in healthcare before, particularly healthcare assistants who have had only 2 or 3 days induction, and they feel that it's very inadequate and they're afraid of saying anything. That's a shockingly short period of induction for anybody coming in to provide personal care for people, and certainly they should say to their employer what opportunities are there for learning. But I would say you could signpost those people to the Royal College of Nursing. Healthcare assistants are, of course, welcome to join the RCN, and we have lots of education resources that might help build people's confidence, although I do think it's the employer's responsibility to properly train people. If they want additional advice and learning, they can certainly get that via the RCN. We'll come to the end of our time. Sorry, Claire,
Norman,
very quickly.
There's a really good training on our website called First Steps that you don't have to be a member to access, and that is great initial training for care support workers working in the social care sector.
Great, thank you very much for that, Claire. That's really useful. Useful advice, Claire, thank you. So we've come to the end of the event. I hope that you found it useful. We've tried to answer all of the questions that were posted in the chat. In the chat, there is a link for you to fill out an evaluation for having attended today, just to give us feedback, because it's good for us to learn what you think went well, what you think we could do better. So if you could follow that link and fill in the evaluation, that would be enormously helpful for us. So thank you all for joining us tonight. I hope you found it useful, and I would just once again say that you could signpost other people to this if you think it would be useful to them. It will appear on the website within a couple of weeks, and they can watch back and hear the presenters with the very valuable advice that they've given you this evening. So thank you very much for attending.